Well, good morning, members and friends of the Global Chamber, Baltimore and Washington, D.C. And hello to all who may be joining from the other metros in different part of the world. Hi, my name is Mi-Jung Hibitz, the Executive Director of the Global Chamber, Baltimore and Washington, D.C. Global Chamber is the first chamber of commerce focused on helping companies and communities grow cross-metro and cross-border trade and investment around the world. We are helping members in more than 525 metros in more than 195 countries. Welcome to today's Globinar, Legal Issues in International Sales Post-Pandemic. After almost a year and a half has passed since the pandemic, the global economy now is booming, even though there are some growing concerns of the Delta variant spreading. Now, many companies are resuming businesses, their development activity, visiting distributors in different metro, domestically and overseas, and business trade exhibitions and conventions are slowly coming back, often in a hybrid model that offers both in-person and virtual options. Well, as we continue to accelerate our effort to increase international trade and sales and growth post the pandemic, we thought that it would be great to put together a webinar around the legal issues that U.S. companies engaged in international trade should pay attention to, especially for the small and medium-sized companies that have just started the journey of international businesses. Understanding key legal issues in international sales would be very beneficial. And now let me introduce today's speaker, Attorney John Jack Shelton, partner at Aegis Trade Law. Jack serves as outside general counsel for domestic and international businesses, and his background places a particular emphasis on serving importers, exporters, and the space, defense, and maritime industries. He received his JD from the University of Tennessee and his LLM in Admiralty Law from Tulane University. He began his legal practice working in Germany, representing an ocean carrier, and then moved to New Orleans to represent the international businesses in Gulf of Mexico. Jack is admitted to practice law in the courts of DC, Tennessee, Louisiana, and the U.S. Court of International Trade. He's also a licensed U.S. customer broker. He's joining today from beautiful Albuquerque, New Mexico. He's a member of the Global Chamber of BWI and has newly joined as our advisory board. So during his presentation, if you have any questions, please share, or the comments, please share them in the chat box, and we will address them after each topic and also all together after his presentation. Doug Bronke, CEO and founder of the Global Chamber, will moderate a Q&A later part after Jack's presentation. So Jack, now the floor is yours.
Thank you so much for the intro, Mi-Jung. I really appreciate it. Welcome, everybody. So in this presentation, we're going to be talking about international sales, as you can tell from the title. We're going to try to do a series of these presentations. So we're going to cover some things in this one. If we don't end up finishing it, we'll kind of push those items to the next webinar that we do. But one of the things that Mi-Jung asked me to present on was to kind of put all this in context of the pandemic. And during the pandemic, I had several of my clients asking me to help them importing PPE, personal protective equipment, such as masks and gloves, which became a really booming trade during the pandemic. Unfortunately, there was a tremendous amount of fraud happening at the time. There were a ton of players in the market who were very new to international trade and didn't quite know what they were doing. And one of the things that we realized was that both among new companies and among companies that have been around for a little while, a lot of people didn't know some of the fundamentals of international trade. For example, how a contract is really formed, what purchase orders really are for, and what the legal function of them is, and how a lot of these things work. So we really wanted to kind of stress some of the fundamentals. We're not going to go terribly down into the weeds with a lot of this stuff, but we want to give you a basic understanding of a lot of the key issues in international trade and how all of this works. So just a little bit about me. Mi Zheng already introduced me, but my law firm is called Aegis Trade Law, and we focus on international trade. We do a lot of work with companies in the commercial space industry, such as like satellite companies and launch companies and things like that. If you want to reach out to me, you can go to jack@aegistradelawcom. That's my email. Our website has a contact form. You can also find time on my calendar if you go to the website. And then there's my LinkedIn. So what we're going to try to cover today, and again, if a couple of these issues we don't get to, we'll just push them to the next one. We wanted to kind of open up questions as we're going, because frankly, there's a few different topics, and as we change topics, I want to make sure that people get an opportunity to ask questions so that they don't get too confused and hung up on an issue. So first, we're going to talk about what is the point of a written contract? Why do we even have them? If you have a contract, what law is going to govern it? We're going to talk about how contracts are formed, recommended terms that we usually have in our international sales contracts. We're going to talk about something called Incoterms, which is a set of 3-letter acronyms that you've probably heard of, like FOB and CIF and things like that. And they've been defined by the International Chamber of Commerce. If we can get to it, we'll talk a little bit about agents and distributors and how exporters typically work with those people. And then we'll touch on how a company might be taxed in 2 different countries if they have something called permanent establishment. All right, so let's dive right into point number 1. So what is the point of a written contract? So a lot of people sometimes think when they're new to contracting and they haven't been in a whole lot of disputes before, they really kind of look at the contract as only something that they will use if they have a dispute and that they can take to court and enforce their agreement. There's actually a few more reasons why we have this. And that's why it's important to think about this when we're drafting our contracts, because we want to hit all of these points really well. So first, it forces the parties to think about all of the details up front. Once you get into a contract, like if you've got that handshake agreement for a sale of goods, and you haven't gotten into a lot of the nitty-gritty details, somebody at some point is going to be disappointed. And when that happens, then you're going to start trying to hash out some of these details and say, oh, why didn't you deliver it this time? And people are going to be harder to work with once you already have a deal in place, once people have already started to perform. So it's important to get all of the details out up front and put it in writing so that you don't have that issue come up later. People will be harder to work with later. Second, you want to remind the parties what the terms are when you're performing. Frankly, memories change. Human memory is terrible. It's one of the reasons why we typically say in a lot of like criminal cases, for example, that eyewitnesses it's the worst kind of evidence because human memory is really bad. And so we want to take all of the terms that we've agreed on, write them all down in some sort of form so that as issues arise, we can both parties go back and look at the terms and say, wait a second, yeah, we actually did already agree on this. We talked about it. Third is you want to explain, if you do get into a dispute, to a judge or a jury or an arbitrator, whoever's deciding the case, what the terms of the contract are. Now, this is actually pretty important in international trade, that you want to be really detailed explaining a lot of the things, because judges and juries often don't understand the commercial context of international trade. This stuff is new to a lot of people. We've been in front of judges before who spent their entire career handling divorce cases. And then we've got an international trade case presented before them, and they have no idea what's going on. They don't have the slightest clue. So we have to spend a lot of time educating the judge. But then if certain things are left out of the contract and we have to explain to the judge, well, this is the normal way things are done in international trade, that judge doesn't know if I'm lying or not. So it's important to put as much detail into your contracts as you can. I like to write all of my contracts in such a way that an uninitiated person with a 9th grade reading level can understand it. That's what I always strive for. Frankly, when you have too much legalese, too much legal language in a contract, and it becomes really dense, it becomes really hard to read. It becomes harder to understand. And what you're striving for, usually at least, is for everybody to actually understand the contract. If everybody understands it, they can perform. Now, maybe there are certain instances where we want something to be a little bit vague because that can be to our advantage, but usually this is the case. So the 4th reason why we want to be really clear in our contracts is so that if we ever go to court, we can hopefully win something called a summary judgment. So a summary judgment is a legal device that lets you win without having to go to trial. It lets you win really early in the process. Now, people don't often win summary judgments because they're usually factual issues that arise. But if we have a really good contract and everything is documented really well, hopefully we can win a summary judgment. So the rule of summary judgments is if the terms of your written contract are unambiguous and the facts are disputed, or actually that should say, and the facts are undisputed. Sorry, I have a little typo in my slide. So if the terms are unambiguous and the facts are undisputed, you can often win a case much earlier in the process without going to trial. You save a ton of money. All right. One other thing we need to talk about is something called the parole evidence rule. And this applies particularly in common law jurisdictions like the United States, the UK, and Canada and Australia, and places like that. Basically what it says is when you have a written contract, the evidence about the party's intent, if it's not contained within the written contract, you can't even introduce that evidence. So if a provision in a written contract is unambiguous, the parties will not be allowed to introduce what we call parole evidence of what the term means. So what we often see is we'll have a written contract. And sometimes one of my clients will say to me, yeah, okay, this is what it says in the contract, but that's not really what we meant. We really meant something else. Well, if it's written and it's unambiguous, he is not going to be able to go to court and argue that the parties actually had a different meaning, and a different intent about what that paragraph meant. Instead, the paragraph is what it is. The written language is what it is. So what if the terms in your contract are, in fact, ambiguous? Sometimes we have commercial jargon in our contracts, but we fail to define that commercial jargon. Sometimes we have a commercial context that is implied in our contract, but we don't bother to explain it. And that can create problems because then sometimes we have to have an expert witness come and testify about what things mean and what the commercial context is. So if you have that ambiguity, this external evidence might get introduced, which is a problem. You can introduce written correspondence, you can introduce testimony of the parties, you can introduce testimony of expert witnesses. All of this costs a lot of money. This prolongs the process of the trial. And the expert witnesses, you have to pay them as well. And just as a note, I mentioned the parole evidence rule applies under US state law. It applies in other common law jurisdictions. It doesn't apply in a lot of civil law countries. And it also doesn't apply under the United Nations Convention on Contracts for the International Sale of Goods, which is the CISG. We'll talk about this law in a little bit. This is a treaty between a lot of different countries, including the US. All right, so what law is going to apply to your contract? So first, you can typically choose which law applies to your contract. And you always want to do this in your contract. So the parties should always choose which law will govern. And typically it's either going to be the law of the buyer's country or the law of the seller's country. If the parties don't actually make the effort to choose and put it into their contract, it's going to come down to several different factors, and it's kind of a complicated analysis. So you'll end up looking at like which party sued first, where the lawsuit was brought, and there's this whole complicated analysis based on that stuff. In this presentation, we're really only going to focus on US law and then the CISG, which I'll introduce that topic in just a moment. Frankly, there's 190 plus different countries, and I don't know the laws in all of the different countries. But US law and CISG is what we'll focus on. All right, so first, we've got this hierarchy in in international trade involving the US. We've got this hierarchy of laws. So first, if the CISG can apply to your contract, it's going to apply first. Then we're going to look at, if that doesn't apply, we're going to look at UCC Article 2. This is something that's state law in most of the states. And then after that, we're going to look at state common law in the US. So first, let's look at the CISG. It is an international treaty, and it applies when both the buyer and the seller are both in countries that have adopted it. I've got a link, I think on our website, we've got a link in the navigation menu to laws and regulations. And we've got a link to the CISG, and I believe we also have a link to where you can see which parties have adopted the CISG. I'll check on that and make sure it's there. So the parties can contractually opt out of the CISG. So even if it would normally apply because the buyer is in the US, for example, and the seller is in another country that has adopted it, such as China, even if it normally applies, the parties can opt out of it by putting into their contract that they opt out of it. There's actually some disagreement, though, about whether the parties can opt into it. But if you want to try, it doesn't hurt to try. So what about UCC Article 2? So this is US state law. It's adopted in 49 states. Louisiana is a little different. Louisiana is a civil law state. It's the only civil law state in the US. If the CISG doesn't apply, UCC Article 2 is the next in line. But even if the CISG does apply, sometimes the UCC fills in gaps. For example, the CISG doesn't deal with when title transfers from the seller to the buyer. And so even if the CISG does apply, if we're looking at that particular issue, then we look to UCC Article 2. And then if there's something that isn't dealt with either of those, then we look at state common law usually. It's state-specific, judge-made law, and it's usually released in legal opinions. All right, and again, it can fill in any gaps, or it applies if those other two sets of laws don't apply. Once again, Louisiana is a little weird. It's not a common law jurisdiction, so this area of law doesn't apply quite as to the same extent Louisiana. All right, so when do the UCC and the CISG actually apply? So UCC Article 2, again, in the US, it's been adopted in 49 states. Louisiana is a little different, and it applies to the CISG. Doesn't apply, it fills in gaps. CISG, meanwhile, just to recap, it applies when the buyer and seller are both in countries that have adopted the CISG. And the US and most of its trading partners have in fact adopted it. There are a few exceptions. So UK, India, Brazil, South Africa are all countries that have not adopted the CISG. So it won't apply between the UK and India, for example, or between the UK and the US. There's also a few places like Hong Kong, Taiwan, and Macau, where there's some disagreement because like Hong Kong, it's a special administrative region of China. China has adopted the CISG, but Hong Kong, I believe it was in 1997 when the British, when Britain signed the treaty with China, and there's this whole historical mess, and it makes it unclear as to whether it applies there. All right, so that's kind of a brief overview of those different laws and when they apply. Let's talk a little bit now about creation of a contract, how a contract actually gets created. So this is kind of a common scenario with new clients. Sometimes when they come to us with a problem, they'll say something to the effect of, hey, we bought $250,000 worth of merchandise and it arrived defective. Please help us. And I'll say to them, okay, please send me the terms of your contract. They'll say, well, we don't have a contract. I say, yes, you do. A lot of clients think that a contract is only a single document that has both parties' signatures at the bottom. And that's really not true. A contract can exist in many different forms. In international sales, typically the form that we see contracts in is a purchase order and then some sort of communication accepting the purchase order. And that creates a contract. So let's look at how contracts are actually created under law. So first, just talking about what a contract actually is. Contract is simply an agreement between two or more people that contains one or more promises, such as a promise to deliver goods and a promise to pay money. And it's also enforceable under law. If it's an agreement between two or more parties that has promises in it and it's enforceable, it's a contract. So how do we know whether something's enforceable? So we look at these elements to determine that. So first, there has to be mutual assent. Both parties have to agree to it. And the way we generally demonstrate mutual assent is through a process of offer and acceptance. So we have a communication from one party that offers a set of terms, and then the other party accepts that set of terms. So for example, a purchase order is very often considered an offer. And if a seller accepts a purchase order and says something to the effect of, hey, we'll get started on this, then you have a contract. Next, in common law jurisdictions, such as the US, another element of an enforceable contract is something called consideration. Consideration is merely some sort of a quid pro quo. Courts in the US and the UK and other common law countries do not like to enforce something that is just a unilateral promise, something that's just a gratuitous promise. So for example, if I see my neighbor tomorrow walking down the street and I say, hey, I'm gonna give you $5,000 tomorrow. And he says, okay, great. And then I don't do it. He can't sue me in the US because that's just a gratuitous promise. There's no consideration. He didn't promise to do anything in return for that $5,000. He didn't promise to give anything up in exchange for that. Therefore, the court won't enforce it. Under the CISG and civil law countries, consideration isn't really an issue, but it is in common law countries. Next, to have an enforceable contract, you have to have legal cause. Sales of goods are always a legal cause. There's nothing wrong with selling PPE, gloves and masks and things like that. But if, for example, I had a contract to assassinate someone, that would not be legal cause. And if I failed to follow through with my contract to assassinate someone, the other party couldn't sue me for breach of contract. And finally, we've got capacity. In many contexts, we think about capacity as the person has to be of sound mind. They can't be, for example, insane. If they sign a contract, if an insane person signs a contract, you can't enforce that contract against the insane person. If a 5-year-old child signs a contract, you won't be able to enforce the contract against them because they don't have mental capacity. In the corporate context, it's important to remember that only certain people within a business have capacity to enter into an agreement on behalf of that business. So for example, a CEO of a company usually has capacity to sign contracts on behalf of a corporation. The receptionist of the corporation who just answers the phone typically does not have the legal capacity to sign contracts on behalf of the corporation. And then there's a question as to whether there's a writing requirement. And this is something that there's a million different caveats to it. So I'll just leave it at that. But under the UCC, if you have a contract that's worth more than $500, it's supposed to be in writing. However, again, there's a million caveats to that. And very often contracts will be enforced even if they're not in writing and over $500. Under the CISG, there's no writing requirement. But that is a really important note here. If you don't have a contract that's in writing, good luck trying to enforce it. You're probably going to spend a ton of money on attorneys and not get anything in return. Okay, so let's talk about the communications between a buyer and seller that can either create a contract or prevent a contract from being created. These communications are called offer acceptance, rejection, counteroffer, and revocation. So what's an offer? So an offer is a communication that a reasonable person would understand to invite an acceptance, with that acceptance then creating a contract. So if I have a set of terms that I present to another party and they accept that, we would have a contract. So for example, I send a purchase order and I clearly indicate that if they accept that purchase order, we're gonna get going. I'm gonna pay them for the goods. And if that other person accepts, that would create a contract. So that purchase order could be an offer. An acceptance then is just a communication in response to an offer that a reasonable person would understand to create a contract. Offer and acceptance can be communicated in just about any way. They can be created orally. They can be created in writing. If I orally communicate an offer to a person and then they smile real big and give me a thumbs up, that might create a contract. That sort of communication might be enough to accept my terms, depending on whether a reasonable person would believe that communication accepted it. An acceptance must be given in a reasonable amount of time, and we'll talk about this in a little bit. If I offer something to someone and then they come back 3 years later and accept it, typically the offer is no longer good. It has expired. And I can even put dates around my offer. Say, hey, here's an offer. Here's the terms I want. You have 2 days to accept this offer. And if somebody accepts it after that 2 days, the offer is no longer on the table. Next, rejection. This is quite simply a communication in response to an offer that declines the contract. So I offer terms, the other person says, no, I don't want that. A counteroffer is a communication in response to an offer that rejects the offer, it proposes different terms, and it invites acceptance. So I make an offer, the other person says, no, but what about these different terms? That person then becomes the offeror, and then I become the person who accepts or rejects. And then finally, revocation. This is where the person who makes the offer communicates that he is withdrawing that offer, and it has to be done before the offer has been accepted. Because once it's accepted, it creates a contract. So revocation, withdrawing that offer, has to happen before the acceptance. All right, so we're just going to go through a couple really simple, quick examples really fast. You've got a buyer and a seller. Buyer says, hey, I'll pay you $500 for you to make me 2 widgets. Seller says, okay, I'll get started. You've got an offer, you've got an acceptance, boom, you've got a contract. What about offer and rejection? Buyer says the same thing, I'll pay you $500 for you to make me 2 widgets. Seller says no. Hey, no contract, okay. Offer, counteroffer, and acceptance. I'll pay you $500 for you to make me 2 widgets. Seller says no, but I'll make them for $700. Buyer says it's a deal. Okay, great, we've got a contract based on these 2 communications. It's gonna be $700 for that contract. What about offer, counteroffer, and rejection? Really simple. I'll pay you $500 for you to make me 2 widgets. No, I'll make them for $700. No. Okay, no contract, obviously. Pretty simple, right? And then finally, an offer and a revocation. The buyer says, I'll pay you $500 for you to make me 2 widgets. The seller doesn't respond quite yet. And then the buyer says, I changed my mind. Okay, no contract now. If the seller had accepted before the buyer says, I changed my mind, you would have a contract, however. So it's important to remember the timing. Okay, let's go ahead and open it up for questions. The next couple slides kind of get into the weeds a little bit, and I think I'm going to skip over them.
Yeah, sure. There was a one question, Jack, in Q&A box. So regarding which forum applies in a contract, US does not have exclusive national laws in many cases. and state law may apply. How does this factor in a decision on where to file?
Fantastic question, Larry. So, for example, if I'm writing a contract for one of my clients who is US based, we're going to have a clause in the contract called the governing law section, right? It's going to say governing law and venue, which law applies and where is our lawsuit going to be determined. When I write that clause, I don't simply say US law applies. That's not enough. I say New York law applies or Texas law applies. Because if we go back to the discussion about the UCC is state law. Now it's uniform across the different states, but again, then we've got the state common law below that. And that is sometimes going to apply to some of our issues. So it's important that you not just pick US law, you actually pick a specific state law that applies. And then you'll also pick the venue. You'll say any dispute arising under this contract is going to be decided by a court in Shelby County, Tennessee. You get very specific about the county that you want it to be held in. Or you're going to have it in arbitration, but you still pick the specific place that's going to be held.
All right. And then there's another question in chat box. Well said. We have many small and underrepresented organizations interested in doing business internationally. Where can they go to get a summary of best practices for global commerce, hopefully in plain language?
Okay, it looks like that was from Chris. So our firm has been obviously putting these webinars together. So of course, first thing I would say is, hey, watch these webinars and hopefully this is plain language enough that, and I'm explaining it well enough. We've also been putting together some pre-recorded video content that we are packaging, and maybe that would be something that some of your folks might enjoy watching and get something out of. Aside from that, let me think. The Dunlap Stone University has some really good content. And outside of that, it's really hard to find, frankly. There is one book that I really like, and it is called, I want to say that it's called Policies and Procedures in International Trade or something like that. I will put it in an email, and maybe Mijong or Doug can send it out to everybody after this, after I look it up and find it. I can't remember the title, but it's a fantastic book that explains things really well.
That sounds good. That sounds good. Well, we Global Chamber also put, webinars in the form of a webinar and Globinar, some of the important legal issues and an update as well. And BWI is planning some series of important key legal issues for the companies who wanted to do business internationally. So that's something to watch as well. Another question, it's mine. Jack, can you share a specific examples of Parol evidence rule you have handled, if you have some specific example?
Oh God, yeah, gosh, there's a ton. So I'm trying to think of something that's clever. So just for example, parole evidence rule often comes into play when a party hasn't defined a term very well. And so I'm just trying to think of some of the terms where this has come about. But you've got some ambiguity in just a word, for example, that hasn't been defined. For example, if you fail to incorporate Incoterms into your international sales contract, and you say, for example, delivery must be completed by a certain date, sometimes there can be ambiguity about, well, what does delivery mean? Does it mean you put it on the ocean carrier? Does it mean when it actually arrived at the buyer's premises? What does it mean? That's one of the reasons why we use Incoterms, which we'll talk about in a little bit, because that really helps define what delivery means.
Yeah, that's excellent questions. the answers actually. Thank you very much. And
Yeah.
one more, can you discuss international arbitration in the context of disputes?
Sure, there's a ton that we can say here, and so I'll try to be pretty brief. The United States and a lot of other countries are party to what's called the New York Convention on Arbitration Awards. The formal name is actually something a little bit different, but that's what we all call it. We all call it the New York Convention on Arbitration Awards. What it says is that, for example, let's say that I am suing a seller in China and I'm representing a buyer in the United States. If I go to arbitration against that Chinese seller, we go to arbitration, we have the arbitration in New York, I get an arbitration award from my client. I can then take that arbitration award to China and I can go to a court in China and say, I've got this arbitration award, please enforce it. And the treaty between the two countries says that the Chinese court must enforce my arbitration award, with a few exceptions that are hard to find. Now, imagine instead of arbitration, I had gone to court in the US. Imagine we had both agreed that there's going to be a lawsuit in a court in Shelby County, Tennessee, which is where I'm from. And we get that court decision, get a court judgment, and I take that same court judgment to China. And I go to a Chinese court and say, please enforce this. That Chinese court is going to laugh at me and say, go away. So arbitration awards are very often more easily enforced in foreign countries. And that's why we often default to that in international sales. There's a million more things I can say about it, but that's the most important, I think.
Awesome. I think we cover all the questions for the topic one. So with that, we can proceed to the next chapter.
Fantastic. All right, I'm going to skip around a little bit. I'm going to go ahead and skip through this section because I think I've covered it enough and we can get to the next thing. All right, let's talk about offer and acceptance just a little bit more in the commercial context. So in the commercial context, when you've got international sales, you've got a buyer in one country and a seller in another country. Typically, this offer and acceptance happens through trading documents, right? And so there's a whole bunch of documents that are flowing back and forth. There's a whole bunch of written correspondence going back and forth. And so it's important to identify which communication is the offer and which one is the acceptance. And it looks like I've got a little error in my animations in this slide, so I apologize about that. All right, so the first communication that often happens is the buyer will reach out to the seller and they will ask for a quotation, right? They'll say, hey, I want this widget. What would you charge me for this widget? And then the seller will often come back with a quotation. And sometimes the quotation will say, it's this price for a certain Incoterm, and it's another price for another Incoterm. So for example, it's this price if you're picking it up at our facility, but it's this price if we deliver it to your door. And it's another price if our delivery just includes putting it on a vessel. Often that quotation comes in a form called a pro forma invoice. And a pro forma invoice is a lot like a normal invoice. A normal commercial invoice, it's a, the function that it serves is it is a demand for payment. It says, hey, this is the stuff I sold to you. These are the details. Here's the breakdown. This is the price. You owe me this price. That's what a commercial invoice does. Pro forma invoice is meant to look just like the commercial invoice so that the buyer knows what commercial invoice is coming later. However, it's not a formal demand for payment. That way it can function like a quotation, and sometimes it's also useful in certain other contexts. So after that quotation comes, there might be some back and forth, and then the buyer is going to submit a purchase order. And the purchase order usually, in most cases, is going to be deemed the offer. Then the seller comes back and communicates. Usually either they'll just communicate, hey, we've got your purchase order. We acknowledge that you have sent it to us. Give us a minute to come back to it. And of course, that wouldn't be an acceptance that creates a contract. It's just an acknowledgement. Or they might respond and say, we accept. Thank you for sending this purchase order. We accept. We will go ahead and get it packaged for you. And then finally, once the goods have been prepared and packaged up, And some they've completed some delivery obligation, then they send the commercial invoice. So once again, that purchase order is usually considered the offer. And then if the seller communicates acceptance, then that creates a contract. Sometimes this can be flipped on its head. So sometimes if I represent a seller, sometimes I tell them to put language in their pro forma invoice, in the quotation, that actually says, this is an offer. If you accept it, then your acceptance creates a contract. And that's because I don't want the buyer to send purchase orders to my client, because they might try to put different terms in there that I don't like. We'll talk about that in a little bit. Well, actually, we'll talk about that right now. So what happens when you have different or additional terms in some of these different communications? So for example, you got a quotation that has certain terms attached to it, and you've got a pro forma invoice, a purchase order that the buyer sends over, and it's got different or additional terms in there. What's going to apply when you've got this mess of terms conflicting with each other? So for example, this is just really simple. You've got a purchase order that the buyer submits, and it's got the buyer's standard terms and conditions on it. And let's say that the purchase order says, I'm going to buy some widgets. The price is $500 for 2 widgets, and the delivery date is May 5th. Okay. Then the seller submits an acknowledgement document that is purporting to accept the purchase order. And they're basically sending an acceptance document saying, hey, we accept. Here's our terms and conditions. And then it says, same thing, price $500, quantity 2 widgets, except there's something different here. It says, instead of May 5th, it says June 5th for the delivery date. We call this a different term. A different term is one that conflicts with something that's in the other document. And then there's something else in there that says, if there's a dispute, there's going to be arbitration in China. Now, there wasn't an arbitration or dispute resolution clause in the first document. So since this isn't a direct conflict, it's just something additional, we call that an additional term. And different terms versus additional terms are treated a little bit differently when we go through our whole analysis. And so when you've got these different or additional terms, 2 problems arise out of that. First, have we really had a true acceptance of these terms? In other words, do we even have a contract? Because remember, a contract relies upon an offer and an acceptance usually. So we have to do this whole legal analysis about whether a contract even exists. Okay, now suppose that we do have a contract. Which terms apply? Is it going to be June 5th or is it going to be May 5th? Do we have arbitration in China or does that get stricken? Now, we've got a special term, a special phrase we use for this. We call it the battle of the forms. And if I talk to just about any lawyer, if we're out having drinks and I mention the battle of the forms to that lawyer, I can watch the blood drain out of their face, because this is something that everybody hated learning so much because it's really complicated and it's tedious and cumbersome and it doesn't make a whole lot of sense and it's difficult. We do this quite a bit. We deal with the battle of the forms in my firm quite a bit, so we understand it really well, but most people don't understand it. And just as problematically, the judges don't understand it very often. And so you have to explain this stuff to the judges. Once again, remember, we might take a case to a court and that judge maybe was a divorce attorney for 30 years and they became a judge 2 months ago. And they know nothing about the battle of the forms. They especially don't know anything about the battle of the forms in the commercial context. Often, if we go to arbitration, sometimes we have an arbitrator who is an expert in international trade. But even then, I don't like to rely on their understanding of the battle of the forms because it's complicated. We have to write a ton of memoranda explaining it to people, explaining it to the judge or arbitrator. And so it's something that we try at all costs to avoid. I'm going to skip through some slides now, talking about the battle of the forms under the UCC and the battle of the forms under the CISG, because you're going to want to put a bullet in your head if I go through all of this. I usually reserve these slides for people who really want to learn this stuff. But instead, what we're going to do is talk about how to avoid the battle of the forms. So buyers, if you're trying to avoid the battle of the forms, which you should do if you're smart, first, put a signature line on the bottom of your purchase order. If you send a purchase order to somebody and you sign the bottom and you've got a signature line for the seller to sign it, that can create a contract because their signature communicates their acceptance, right? And so you might add language to your purchase order that very explicitly says, this purchase order is an offer, and by signing it, you accept its terms. Then they sign it, they accept it, boom, you've got a contract. If they then try to send additional terms over or different terms, they don't amount to anything. You've already got a contract. So next, sellers, kind of the same thing. If you're a seller, you can try to get the buyer to sign your quotation, which again might be in the form of a pro forma invoice. Just put a signature line at the bottom. You add language that says, this quotation is an offer. By signing it, you accept its terms. If you do that, you get to avoid the whole battle of the forms, and you get to avoid them trying to insert their terms and conditions. All right, so I'm gonna try to move ahead really quickly. Instead of doing another Q&A right now, we're kind of running out of time. So let's talk about some recommended terms and conditions that we always try to put in our international sales contracts. So first, our law firm has an international trade checklist. This is my pre-flight checklist that I go through every time I've got an international sale in front of me that I'm trying to draft or I'm reviewing somebody else's. And you can actually find this checklist if you go to our website. Again, it's aegistradelawcom. Right down there at the bottom, you can see that. And if you go to, I think the link is called free resources on our website, you can find this. If you use this document, it's going to cover just about every issue you can think of that you need to have in your international sales contract for the overwhelming majority of cases. So let's talk about some of the issues that you always want to be thinking about. So first, price. When does somebody have to pay? A mistake that people often make is they think that the Incoterms governs the price or when the price is paid, and it doesn't. Incoterms does not talk about when price is due. What currency is it going to be in? Is it US dollars, or is it going to be in pounds sterling or something else? What about taxes? Sometimes in international sales outside of the US, for example, you've got value added tax for wholesale sales. And so sometimes you want to deal with who's paying that value added tax. And also another form of tax is import duties. So you want to cover who is responsible for paying import duties. The Incoterms actually does cover who's responsible for that. Are there any offsets allowed? So for example, sometimes I'm going to enter into some sort of a deal where I'm buying from one seller multiple times, and they might ship me 2 different things. And in the first instance, they send me some goods that are defective. And then they send me a second shipment under another purchase order, for example. Can I deduct the cost or the value of the defective items from purchase number 1? Can I deduct that from purchase number 2? So we like to deal with offsets. Payment terms. When is somebody going to be paying? Is it cash in advance? We really like to do cash in advance through an escrow process. I'll talk about this just a little bit more in 1 second. Next, you've got letters of credit, documentary collections. There's 2 forms of that: documents against payment and documents against acceptance. And then finally, you've got open account. This is where the buyer pays at some point after the goods have been delivered. In a subsequent webinar, we're going to talk all about these different payment methods because there's a tremendous amount to learn about all this stuff. And it's actually really important that people know this stuff. But just really quickly, when we were dealing with a lot of these PPE sales, a lot of folks wanted to purchase and sell through letters of credit. Now, letter of credit it's a really secure mechanism of payment. You've got a situation where the seller doesn't trust the buyer and the buyer doesn't trust the seller. So the buyer does not want to pay cash in advance before the goods ship. And the seller doesn't want to sell an open account. They don't want to just ship and then hope that the buyer pays them. because these parties don't know each other, right? And so one thing that people often resort to is called a letter of credit. And this is a document that a bank issues in the buyer's country. And the bank says, hey, you don't need to rely on the buyer paying you. We, the bank, are going to pay you. And we will pay you when you present certain documents to us. If you present a document called a bill of lading, demonstrating that the goods have been placed on a ship bound for our buyer, and then you present a commercial invoice and you present a document showing that the goods have been insured and a few other things, which prove to some extent that you've complied with the contract. Once you give us those documents, we're going to pay you the money. And because we can typically trust banks to pay when they say they're going to pay, people trust letters of credit. One of the issues we ran into in the PPE market is that with small and medium-sized businesses, letters of credit are a tremendous pain. They're quite expensive. They're incredibly cumbersome to deal with. The banks take forever to approve the deal in the first place. And then we had several deals where the bank takes the buyer's money so that they can then pay it to the seller, but then the seller fails to deliver. And the bank is supposed to then give the money back to the buyer. But what happens is the bank says, well, we're worried about potentially getting sued, so we're going to hold on to this money for 60 days. And everybody's just like, what are you talking about? Everybody's agreed that the seller didn't fulfill their obligation. Why are you holding on to the money? And they say, oh, well, we just want to, essentially. It's our policy. So letters of credit are, I have not seen a situation where a letter of credit worked out well for a small or medium-sized business. Instead, we offer escrow services in our firm. A lot of other law firms offer escrow services. There's also a website called escrow.com. One of the things that's a little bit different about the way we do it is we will actually review documents the same way a bank is supposed to under a letter of credit in order to, and have that be the triggering mechanism for payment. Most escrows simply rely on the buyer to tell them that the goods have been delivered and they conform to the contract. All right, next, a description of the goods. This one seems kind of obvious, but you clearly want to clearly define what goods are being sold in your contract. But sometimes parties really fail to do this very well. And they'll just say, you know, we want these 2 air compressors or whatever. And maybe they'll put a model number in there or something like that. But you want to be very specific about what you're buying and what you're selling, because the parties can sometimes disagree about what the specifications were supposed to be. When the parties end up getting in a fight and you go to litigation, you go to court or arbitration, it's really difficult for an attorney to make an argument about whether the goods met spec or they didn't meet spec if you don't actually include the specifications in your contract. So one way that you can really easily include the specs without having to like list everything out is you can just like attach a catalog to your purchase order. You can just make it an exhibit. You can make it an exhibit to your contract. Let's see. Another thing you can do is just save correspondence. If you're emailing back and forth about what the specs are, make sure you save all those emails. Again, if there's any ambiguity in the contract about what the specs are, we can at that point ignore the parole evidence rule and look at written correspondence, emails, things like that. All right, what about quantity? Obviously, you want to indicate how many things you're purchasing. You want to be really clear about whatever unit you're using. When we've been dealing with PPE, again, we've been helping customers buy boxes of nitrile gloves. You want to make it really clear that this is a box that contains this many gloves. And there's this many boxes per carton, and you're selling this many cartons. We clearly define everything so that there can be no confusion, because then if a seller sends a carton with boxes and then there's a different number of gloves in each box, that's obviously a huge problem. All right, Incoterms. We're running out of time, so we've got a bigger section on Incoterms in this presentation. We're going to shift that and the other things to the next presentation we do. But just really quickly, Incoterms are these 3-letter acronyms like FOB, CIF, things like that. And you've surely seen these in documentation before. And they define whether the buyer or the seller is responsible for a number of different things. For example, packaging, pre-shipment inspection if it's required, export licenses and other export formalities, import clearance and other import formalities, inland carriage in the seller's country, then international carriage, and then inland carriage in the buyer's country, and cargo insurance if you're going to insure the cargo while it's en route. And the Incoterms also deal with when the risk of loss or damage transfers from the seller to the buyer. In other words, if the cargo is on a ship and it falls off of the ship and it gets lost or it gets destroyed or damaged in some sort of way, does the seller have to replace the cargo? Or can the seller at that point say, hey, it was at your risk during this international carriage, so the buyer then has to purchase replacement cargo? Those are the things that Incoterms deal with. I'm going to go ahead and leave it here and open up the Q&A because we've only got a couple minutes left.
Yeah, great timing though, Jack. Great. We got a few more questions here. So some specific, I guess Doug stepped by, but then he had to also go to another meeting, but he gave a few questions. When should the sellers get an attorney involved? And has the pandemic caused some special cases we should be aware of? You talked about some PPE cases or things like that. If anything that you can add to that, question would be great.
So first question, when to get an attorney involved? So I kind of like to think of attorneys kind of like, I'll use an analogy of doctors. Think about like if you've got high cholesterol and you go to a cardiologist, most people wait until they've had the heart attack or they've got some kind of health problems before they go to the doctor. Meanwhile, if you go to a dietitian and learn exercise, you can cut down your cholesterol and then you don't have the problem in the first place. We kind of operate more like dietitians at my firm. At our firm, we don't actually handle litigation anymore. We've stopped doing it so that we can focus purely on working with companies to get things right from the beginning. And so we operate as what we call fractional general counsel. We work for several different companies and we work as their general counsel. So we're talking to them all the time. We're helping them with their policies and procedures and putting their contract terms together, things like that. And so it's smart if you're doing a lot of international trade to have contract templates that have already been vetted by an attorney who you know and trust, who does international trade a lot. You don't want to have even an attorney who does a lot of like domestic deals. They typically aren't going to understand the issues in international trade just because it's so specific. So it's good to get somebody involved early on. They can help you build out templates that you can use again and again. So for example, your recurring terms and conditions that go into your quotations, you want an attorney to review those. So don't wait to get in trouble if you can afford it, at least.
All right, that's very sound advice. And Chris asks, are there global treaties that may be beneficial to small business for product or service business development?
I'm trying to, Chris, I'm not quite sure I understand the question. I'm gonna think about it for 1 second and see if I can, global treaties that may be beneficial to small business, product and service business development. I feel like you've got something in mind that you're trying to lead me in a particular direction, and it's not occurring to me, Chris. I'm sorry, I'm failing you here, buddy.
Maybe we can find some answers later on. Maybe exchange the email.
I feel like Chris will hit me over the head with something later, and then it'll be very obvious to me. And so, let me.
All right.
Yeah. So Doug, success stories. Most of our success stories come from avoiding litigation in the first place. We like to say that if you get sued, you've already lost to a certain extent. If your contract, and look, anybody can sue anybody for anything. They don't have to have a good case to sue you. But very often, if you've got a very clear contract and you are clearly in the better position of the contract, somebody's not going to spend the money to sue you. And they're going to go to a lawyer, and the lawyer for them is going to say, hey, don't bring this lawsuit. You're a dummy. You've clearly lost already. And so if you get sued, you're already spending money that you don't want to spend. And you're already spending time and a whole lot of heartburn that you don't want to spend. So we like our contracts to be really very clear. And so most of our, what we would call success stories, are not having disputes in the first place. Especially in this gets back to the pandemic issue. A lot of the deals that we were seeing a lot of deals from sellers who weren't really sellers. People who were saying that they had purchased PPE to then sell to the United States when they didn't actually have the inventory. They were lying about it. So we would do a lot of background investigation. We would send people overseas to go investigate. Or rather, we would have somebody in country who's already in country go and investigate. And so we avoided a lot of bad deals that way. A whole lot of the time during this whole PPE thing, I had some of my clients bringing me deals on a daily basis, and I would just say no. That was my main function, to say, don't do that. This guy's lying to you. This guy's a fraudster. You'd have people who would have their attorney, and then you would find out that their attorney had been disbarred for fraud. Just crazy stuff like that. And so you'd have to just investigate every single person you're dealing with in the market. So yeah, those were our big wins, is avoiding problems in the first place.
Yeah, alrighty. Very, very great. Well, it's past 12, but let's see. Chris just mentioned in the checkbox, I'm thinking agreements like a PCT, Patent Cooperation Treaty, and others where many details are covered. So.
Oh, yeah. That's okay. That's good. And this is actually something that I don't know much about, Chris. And Chris, I'm sure you do. So everybody, again, we're going to be doing this series, and Chris is actually going to be presenting a bit on some patent stuff, which frankly, I'm a little bit dumb about patent stuff. I'm not a patent attorney, but Chris is very knowledgeable about intellectual property, and yeah, he can explain a lot of this stuff.
Yeah, wonderful. We have really, great lawyers, who can share really top of the knowledge through our planned series of, legal issues webinar in the future. So hopefully you can spread the word out and have, the more participation, the next time. But Jack, thank you very much for your presentation today, and it was really great. And I'm looking forward to doing the next part. We will advertise the date when date is firmed. But thank you very much for participating and then giving some, great questions as well. And just get connected, along the way when you see, any other events coming out, and hopefully also you enjoy the great summer, weathers and nights, and hope to see you again. Thank you very much.
Thanks, everybody. Appreciate you. Thanks, Mijong. Thanks, Doug.
Thank you. Bye-bye.